Hello, YouTube. This is Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We have a question here from YouTube user Global Family. Global Family asked us, how do you explain a decent first offer and then hitting the brakes? So, a couple different things that could happen here. Realistically, we don't know. Right? Obviously, we'll throw out a hypothetical so everybody has context, and then we'll go from there. So you brought some form of discrimination or sexual harassment claim, I presume, if you're hitting up this channel. Your case is either in the EEOC, some state agency, or in federal or state court. It's pending in one of those places, or you just have a settlement negotiation going under the threat that you're eventually going to file in one of those places. You made an opening demand of some amount of money. Let's call it hypothetically. Let's just say hypothetically you demanded $500K. I don't know what you demanded. I'm just guessing, making up a number, right? And the employer came out and they said, hey, we'll give you 40 because you said a decent first offer. So let's call it 40. 40 grand. We'll give you 40 grand. You asked for 500, but we'll give you 40 grand. And then you say, hypothetically drop, well, no, I'm not going to take 40 grand, but I will drop to 460,000 as my next move. Okay. Go back to the employer. The employer says, no mas, no more, not a penny more. 40 grand's all you get. And your question is, what gives? So I'm not privy to the conversations between you and opposing counsel or between your attorney and opposing counsel, but there's something that may have happened where they may have come out and said, listen, we're going to go big on this first one because we think this is the right number. We don't want to go, we don't want to dicker back and forth a lot on this. Like, we think this case is worth 40, last best final, 40 grand. And you and your attorney may just not have believed them. And that's perfectly fine. It's a reasonable thing to not believe, but that might be what happened. And it might turn out that that was true. They may have sincerely said, listen, the most we're paying on this case is 40 grand. You can have it now or not, but like, we're not going to play any further. It's viable. It's possible. It could really happen, right? Conversely, it's also possible that you demand 500 grand and they come out with 40 and they expect to keep negotiating. And you drop, I don't know, hypothetically, you drop 5 grand. You drop from 500 grand to 495,000. And whoever's making the decision on the other side gets pissed. I don't know if that's defense counsel who's been given power to, authority to settle the case. I don't know if that's a CFO, a CEO, a head of HR, a chief legal officer. I don't know who's got the authority on the other side, but you may have annoyed them. So you made a demand. They made a big move to negotiate in good faith. And you made a little move. And now their back is up. They're looking to fight. They're angry. Entirely possible. Also possible. The employer said, listen, we did the numbers on this. We think we're going to spend 40 grand fighting this case. We think we can win it, but we think we're going to spend 40 grand fighting the case. So you can go ahead and just offer the 40 right now. It's a good deal. We'll get done with the case. We don't have to worry about it anymore. Just done. But 1 penny over 40 grand, we're fighting it to the end. We think we win it. That happens too. There are CFOs out there who are like, listen, I run the data. If a case is going to cost us more than 40 grand, we fight it. They eventually will get burned by some big case that causes them to lose a huge chunk of money. But until they do, that's a great policy. Like, that can cause a lot of trouble for a lot of different plaintiffs who don't want to hold out and don't want to go to trial, right? So, entirely possible that's going on. Also, dark side of the industry could be that, employer hires, employer, thought I saw something moving there. Jeez. I was like, I don't have a cat anymore. What? My cat passed recently. Freaked me out. So, employer goes in to set up a negotiation with in-house counsel, who's already on the payroll, right? Not getting paid extra to get this done. And they go up to 40 grand, trying to get it done. and it doesn't get it done. So then employer says, okay, go ahead and spend the money on outside counsel. Go hire specific employment defense counsel, a specialist, and let them fight it. And employment defense counsel wants to bill, right? So employment defense counsel is like, yeah, you offered 40. That's pretty generous. We should no more than that. They might later offer more. You might have to fight them for a long time. After they had some chance to bill, they might offer more. But they want to work on the case because they're working on the case on an hourly basis. It's how they get paid most often. And a lot of them want to earn some money before the case gets settled. They don't want a settlement immediately, right? God forbid their side's already at 40. Let's say you drop from 500 to, 300. They jump to 80. That case could be done. You might take 80. I'm not saying you would, but they don't know if you would or not. And if you take 80, well, they're not going to get very much. Maybe they billed, 5 hours? Well, it's close to 10 grand, but it's not what they were hoping for. They were hoping for a lot more than that in terms of billing the employer. So entirely possible that's what's going on, right? You're going to have to read context clues because I think you're getting the idea. A lot of different personalities, a lot of different situations, and we're going to have to be informed by context clues to get a general feeling as to what's going on. And yeah, listen, the more repetitions you have, the more you do this, the better your feel is going to be in terms of determining what's going on. 100%. No question. But it doesn't mean that it's not a well-educated guess. It doesn't mean that the context clues can't lead you to a general belief of what's going on. Have a conversation with your attorney. Or if you're not using an attorney, think long and hard about the statements being made to you. People reveal an awful lot in these negotiations. And see what they're saying. See what they're revealing. Hear them out. Ask if they want to go to mediation. You're at 40, I'm at 500. Do you want to mediate? Like, it seems like a neutral third party might help us get to yes, might help us get to a compromise, right? I'm negotiating in good faith. You stop negotiating. That's weird. Should we mediate? Is it? And I don't know if that's something you want or not. I don't know if you feel that's going to show that you're taking a weak position because you then are still pushing the narrative of settlement when they're like breaking down settlement negotiations. I will tell you, if somebody wants to talk about settlement, it pays to listen. Even if you're not going to settle your case, you're learning valuable things, and that has real value. They're valuable things, so they have real value. So, don't sleep on that. But realistically, based on what you're providing me here, I can't tell you what's going on. I can just list you possibilities that I've seen many, 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 many times over. And I hope that has some value for you. If it did, like, subscribe, comment down below, share the channel so it can grow. Take care, everybody.